Hi, Dames members. This is Michelle Thorne, and I'd like to welcome you to our August webinar. As you know, Dames, Differently Abled Mothers Empowerment Society, focuses on taking a holistic approach to helping mothers with special needs children. And a part of that is providing self care tools like our guided meditation, yoga, Pilates, and fitness classes. And the other part is through education, like this webinar series. So today, I'm very happy to have Rebecca Sanders here, and she is going to talk to us about estate planning and how a special needs trust fits into that estate plan. So Rebecca has been a practicing lawyer for the past 7 years and is really kind of focused on this area of law. And so I'm very excited to have her here to answer all of our questions and to show us how a special needs trust works. And so that we can have that bit of protection, that bit of comfort that we need, knowing that our children will be taken care of long after we're gone. So, Rebecca, thank you so much for being here today, and I'm going to let you take it away.
Thank you. So, a little bit about my background. I'm a native Arizonan, born and raised in Phoenix, Arizona. I'm licensed to practice in Arizona. I'm a solo practitioner. My office is in the Scottsdale area. I focus my practice on estate planning, some other areas that go along with estate planning, creating wills, trusts, planning for special needs, of course, trust administration, doing some asset protection work, and also some probate matters. And I also offer complimentary consultations for any new clients. So, first, I wanted to do kind of an outline of the topics that I want to cover today. Um, I want to review estate planning generally and tell you about the components that make up having a good estate plan, because typically having a special needs trust is just a component of the parent's overall estate plan. And with special needs trusts, they really are the cornerstone for planning for special needs kids. If you have a beneficiary with a disability, or maybe an adult child or other family member with a disability, a special needs trust is really a great way to handle it. I'm also going to consider some other issues that come up whenever you're planning for a special needs beneficiary. Um, Things like selecting a good trustee, um, and funding the trust are major parts of special needs planning. So with estate planning, what you're doing is trying to put in place all of the legal tools that you need to deal with what happens if I become incapacitated and I can't act. Who makes my medical decisions for me? Who's managing my money for me, paying my bills? um, and then what happens to my assets after I pass away? Who gets my assets? Who are my beneficiaries? And you're also identifying potential issues, um, and developing ways to handle those issues in a way that takes the guesswork out of these hard issues. So whether it's a special needs child, or your kids don't get along, anything like that, with the estate plan, you're really trying to head off those hard issues. So the main components of an estate plan are having powers of attorney, a living will, a last will and testament, and a revocable trust. And with powers of attorney, um, you'll have a medical power of attorney, and also a what's called a mental health care power of attorney. This is unique to Arizona. And in these documents, you're thinking about who can make a good medical decision for you, and giving those people legal authority to act for you if you can't, so they don't have to go through court to get that legal authority. Um, Another type of power of attorney is a financial power of attorney. It's the same thing. You're identifying suitable people to make financial decisions for you if you can't. With with a living will, that's kind of the pull the plug document. So that kicks in if your medical condition is ever hopeless. Your doctors have concluded that there's no reasonable chance of recovery. And in the living will, you're just saying, hey, keep me comfortable and let me go naturally. Um, Another component of your estate plan is a last will and testament. So in this will, you name who your executor is and also guardians for your minor kids or any individuals who you might have a guardianship over. Another major component of an estate plan is a revocable living trust. So this is for avoiding the probate process, keeping things out of court. Um, in your trust, you can select trustees to manage your trust, your assets, if you can't. So people who you trust. And then the trust document states what the trustee can do with those assets. Um, a significant planning issue for planning for special needs is, does the caregiver have an estate plan? If you're caring for a child with special needs or other loved one, you must have a plan. It's the prudent thing to do. Just think through who cares for your loved one if you can't. Who's managing their healthcare decisions? Who's managing your healthcare decisions? Who's managing your money for them? Um, so, kind of the starting point with special needs planning is create a plan for yourself, create an estate plan for yourself, and identify those big issues and make decisions before something happens. And also, this is kind of a two birds with one stone approach, which can be cost effective when it comes to planning for your special needs child. Um, oh, yeah, one more thing. So, regarding the living trust, um, maybe some of you aren't familiar with what a trust actually is, so I just wanted to kind of explain that concept a little bit more. So, the idea is you're creating a legal entity that survives your death. So, while you're alive, you can be the trustee. So, this means you're the trust manager, you're in charge. Um, and when you die, you name other trustees who can take over for you. Um, they manage your money. They manage your money for your beneficiaries and for your beneficiaries only, no one else. So think of a trust as like a company. So if the owner of the company dies, the company lives on. So people die, entities don't die. And this is a good thing because we want your trust to live on because it allows you to provide detailed instructions for how your money is used and who your money will be used for. And if you already have an estate plan, just a quick note, you should regularly review your plan to ensure that your plan is still current. If there's been any changes in the law, your attorney can tell you if they impact your plan in any way, make any needed changes. Also, if you've had any changes in your family relationships, such as maybe an agent or a successor trustee has gotten a divorce, somebody who you named as a legal guardian for your kid. If someone's gotten a divorce, maybe you feel differently about um, stating that they're the guardian if something happens to you. So, what is a special needs trust? So, just I want to kind of touch on some terms here. So, if I say special needs trust or supplemental care trust for purposes of this presentation, those are the same things. So I'll use those terms interchangeably, but we're talking about a special needs trust. And then For this presentation, I'm going to focus on what's called a third party special needs trust. So, this is different from a first party special needs trust, where the assets in this trust are the disabled beneficiaries' assets. Um, because the first party special needs trust is different because there's what's called a payback provision. So that means that the government receives any assets or funds that are remaining in the account in the trust after the beneficiary has died to repay any benefits that have been paid out to the beneficiary. So that's not what we're talking about. That's a different type of trust. A common example of a first party special needs trust, to give you an example, is a person is injured in a car accident and they receive a big settlement, and maybe they were severely disabled. Maybe they have, cognitive difficulties, and they can't manage their money for themselves. So in that case, usually what happens is a first party special needs trust will be formed by a court to set up a trust for that disabled person from the car accident so that somebody else can manage his money and the person can remain on government benefits. But that trust will say that whenever the beneficiary dies, any assets remaining are paid to the government. Whereas a third party special needs trust, what I'm going to be covering from here on out, does not have the payback provision. Um, and we're also talking about assets in the special needs trust that are usually the parent's assets. So we're talking about an inheritance for a special needs beneficiary. So, a little bit more on what we're talking about. What's a special needs trust? The goal of a special needs trust is to allow the trust beneficiary to maintain any government benefits that he or she is currently receiving, and also allow the beneficiary to easily qualify for other benefits if they become eligible in the future. So the beneficiary would rely on state, local, federal government agencies for basic support and maintenance. And the special needs trust provides for the needs of the beneficiaries that aren't fully funded by those government benefits. So if the trust is properly drafted, it won't replace any means tested benefits that the beneficiary is eligible for as a result of being disabled. And when I say means tested, the government benefits that we're talking about are SSI, Medicaid, or Access, to name a couple. But what do we mean by means tested? So we're talking about entitlement programs that you apply for and the requirements to qualify for these government entitlement programs. They're incredibly strict and rigorous in that in order to qualify um, for the benefits, the applicant must show that they have little to no assets in their name. So you're trying to make yourself look really poor to qualify for a means based government benefit. So, in this application process to qualify for benefits, the state will scrutinize all of the applicant's assets. So, they look at bank statements, they look at any transfers or money that has been given away, transferred from the applicant's name to like a family member or a friend. And if the applicant has too much money, they don't qualify. If the applicant has concealed assets or given away money, the state will want to know about that, and the applicant won't qualify. Um, Regarding these benefits, there are attorneys who handle specifically benefits planning and dedicate their whole practice to qualifying um, people for as many benefits that they're eligible for because the rules are so strict and they change a lot. So there are attorneys out there who know these rules like the back of their hand and can really help uh, get beneficiaries qualified. So I want to look at an example. Um, so a common example of how a special needs trust is created is that a disabled person's parents or other family members create a special needs trust and set it up during the parent's lifetime. Meanwhile, the disabled child can qualify for state entitlements. So he doesn't own anything and he can show that he has very little money and he can get on these state benefits. So, upon the parent's death, the inheritance for their disabled child will be held and owned by a trust and managed by a trustee who they select. And the trustee is the legal owner. The beneficiary doesn't have a legal ownership interest in the trust assets. And then the trust document says that the trustee can make distributions from the trust money for anything additional that the disabled child may need throughout his life, um, that specifically aren't covered by the existing benefits. So, what's the point of a special needs trust? What are we trying to do here? What we're trying to do is we're maximizing government dollars the child is eligible for just based on the disability, and we're also maximizing the inheritance dollars because if something can be paid by the government, we want it to be. Meanwhile, anything else that's not covered can be paid for by the trust. This type of trust also ensures that a child who's currently receiving benefits, they're on benefits, isn't kicked off just because they received an inheritance. That can be really disruptive because sometimes it could change a living arrangement if you lose your benefits. So we just want smooth sailing and to know exactly what happens whenever the parents pass away, who's managing the money, how is it being used, the benefits remain intact. Um, and this also means that your child doesn't have to go through this arduous application process to requalify for benefits that they already did. Um, so what happens if there is no special needs trust in place? The parents pass away without putting together an estate plan, they don't have a special needs trust in place. Well, commonly, what you see happen is parents leave the money to another family member and they have a handshake agreement that uh, Uncle Jerry will receive the death benefit from the life insurance, and Uncle Jerry will use the money to take care of your child. This happens a lot. I see it in my practice. Sometimes it works, but sometimes it does not. There are a lot of pitfalls with planning based on a handshake and not having legal documents in place and things written down. So this is not the best plan because the parents in the Uncle Jerry situation, they have no control over what Uncle Jerry does with the money. Um, there are no guarantees that the money will be used for caring for your child, and there are a lot of pitfalls or drawbacks that a layperson doesn't really think through, just because you're not thinking like an attorney would. So what happens if Uncle Jerry um, receives the life insurance money and then he gets divorced? Um, Without a trust in place, what can happen is Uncle Jerry commingles the inheritance with his other assets and he transmutes that inheritance into community property, and that community property is then subject to division in the divorce. What if Uncle Jerry predeceases you or survives you by a year and then dies? In all likelihood, the money winds up going through Jerry's estate to his heirs, and you don't have an agreement with the heirs. They have no idea what Uncle Jerry was planning to do with this money. So again, the idea is we want the trust established by the parents before they die so that there are rules in place for how your money's managed, who's managing, and the people who you put in place to manage your money can be held accountable. So if they make mistakes, they're going to, you can hold their feet to the fire. Um, so the bottom line is we ensure that your money is properly used for your child. Um, and we'll touch on the role of the trustee a little bit later on in the presentation. So, um, so whether or not you make your special needs trust revocable or irrevocable is something that your attorney can talk over with you. This is kind of a case by case analysis that um, that we'll touch on a bit. So, just to distinguish a revocable trust from an irrevocable trust, a revocable trust is one where the trust maker can still control the assets of the trust. They still retain power. They can alter it, amend it. They can make any change that they want. In a revocable trust, the trust maker uses their own social security number, so it doesn't have a separate tax ID number. There's no need to file tax returns at this point. And then upon the trust maker's death, that revocable trust that you can change becomes irrevocable, which means you can't change it. Your wishes are set in stone. So, with an irrevocable trust, the trust maker, once it's established, cannot make any changes to the trust. They can't terminate the trust or dissolve it. And you have a separate tax ID number. So, when do you create an irrevocable special needs trust? Usually it comes down to how much money you have currently. Do you want to gift assets right now to that trust? Do other family members want to gift to this special needs trust? Um, so those types of factors kind of play into whether or not to make your special needs trust revocable or irrevocable. But at the end of the day, this is something that your attorney can tell you which direction to go. So now we're going to move to discussing the trustee of a special needs trust. So your trustee is responsible for making important decisions that are in the best interest of the beneficiary of the trust. With a revocable trust, you may appoint yourself as the initial trustee and then name successor trustees to serve for you if you were ever incapacitated or to serve after you pass away. Um, a big issue, maybe the biggest issue with planning for special needs, is selecting an appropriate trustee who will serve for your child after you're dead and gone. Um, so, what is the trustee's role? So, the trustee manages your money for the trust or manages the trust for your beneficiary. The trustee must follow the terms of the trust document to the letter because remember, after you die, the terms of your trust, what it says, they're set in stone. Your beneficiary cannot change, um, and the trustee cannot deviate from those terms that you set out. Your trustee is also what's called a fiduciary. So legally, they have responsibilities over the trust assets, they have responsibilities that flow to your beneficiary that we'll touch on. And the trustee can be removed. The trustee can be fired. So if they're bad at their job, um, you can go through court and have a trustee removed and actually hold that trustee personally liable. You can sue the trustee if they make mistakes. So, what do the trustees' duties look like? Well, some basic administrative functions of the trustee is they're going to be in charge of opening bank accounts for the trust, titling the assets in the trust. So after you pass away, some of your assets might flow into the trust via a beneficiary designation. Um, the trustee is responsible for keeping records, for filing necessary tax returns, and the trustee also delegates responsibilities to other professionals. So, for example, they'll hire a tax professional to prepare tax returns for the trust each year, to keep the accounting. Um, the trustee will hire an attorney to advise on when to make appropriate distributions from the trust so that the benefits aren't lost, the government entitlement programs aren't lost. Um, and also, just a note on expenses of the trustee. So, for example, whenever they delegate responsibilities to other professionals because they don't know how to file a tax return, um, they don't know trust law, any professionals that the trustee retains to help manage the trust, these are trust expenses. So, this means that the trustee can pay the fees associated with tax preparation services and any legal fees that the trustee incurs um, in order to do his job well, he can pay these fees out of the trust money. And this is a good thing ultimately because if you name your brother as trustee of your trust to manage the trust, you want to make sure that your brother isn't paying out of his own pocket for any of these expenses. Um, so you want to make sure he's managing the trust properly and keeping your child on his benefits, and he has the funds needed to do a good job. And the trust does that for you. Some other administrative functions we'll go through quickly here. The trustee has to communicate with the beneficiary or a beneficiary's legal guardian. The trustee has a duty to be responsive to the needs of the beneficiary. So, if medical needs have changed, if maybe um, they need to find a more appropriate living arrangement for a beneficiary, maybe the beneficiary has a level of independence and has some hobbies and interests to cultivate, those can be really good distributions. So the trustee needs to be mindful of those types of needs of the beneficiary. The trustee has a duty to consult with the beneficiary and the guardian to identify needed expenditures going forward as time goes on. Um, there's also a duty to maintain an investment balance to meet the beneficiary's need to make sure that the the trust assets are invested properly. And there's also a duty to make timely distributions as it's needed. So now the trustee also has ethical duties. So the trustee is a fiduciary. A fiduciary has to maintain um, the appropriate ethics of the position. So, namely, they must be diligent and skillful in their responsibilities. They must be guided by good faith and fair dealing. Um, they have a duty, an ethical duty to disclose information to the trust beneficiaries or guardians, and they have to be alert and responsive to any issues with the beneficiary. So when it comes to selecting the appropriate trustee. Um, for our purposes today, I'll review some pros and cons associated with naming a family member as your trustee, and also some pros and cons that can arise when naming a professional as your trustee. But the point is, you should talk to an attorney about who's appropriate given your situation, um, because they can kind of cut to the chase and um, eliminate some of your concerns that I'm going to touch on here. So, first and foremost, you can select anybody to serve as your trustee, but it's important that the person who you select understands the duties and responsibilities of being a trustee, and you need to understand that so you can make a good decision. Um, so you'll want to choose someone who will act in accordance with your wishes. Um, with trustees of a special needs trust, in particular, the trustee needs to be really cautious when making distributions because, again, any mistake could potentially disqualify your child from benefits. This is a disruption. This isn't good. And again, the trustee can be personally liable, they can get sued. So, a common issue is that, maybe your family members predecease you as the trust maker, or a family member's situation changes and they can't take on the job. So even if they're named in your document as serving as trustee, filling that role, maybe their life has changed and it's too hectic and they have to decline. So the idea is you kind of create a succession. So if one person can't serve, you have somebody else as a backup. If that person can't serve, you have another backup. And you think through this succession of individuals, and so that everybody who you list is responsible and you've thought through kind of the pitfalls. Um, so oftentimes people select an individual who they know and a few successor trustees or backups. Um, if the need arises, if somebody can't serve, you have a backup. And as a last resort, a lot of times you'll list a professional trustee as kind of the worst case scenario backup. Like if several family members pass away or they have to decline the role, you have someone who's appropriate to fill the role. So when it comes to naming individuals or a family member as your trustee, naming a layperson as a trustee, somebody who doesn't do it every day, might not understand the responsibilities involved. So, given the nature of a special needs trust, sometimes naming a family member is not always the safest course. So, again, with lay people serving as trustees, it's critical that they understand that serving as trustee, they they have legal responsibilities that come with that job. And it's important that they understand that they can and should retain legal counsel so that no distributions are made that'll kick your child off of benefits. Um, so, as a trust attorney in my practice, I see situations quite frequently where a family member is named as the trustee, maybe an adult child or other family friend, and for whatever reason, the person just does not understand the legal weight of the role, um, the nature of the responsibilities of serving as a trustee. Um, I've seen trustees putting trust assets in their own personal names instead of the trust name. I've seen the trustee use the trust funds as kind of a personal piggy bank. I've seen trustees make distributions to beneficiaries when the trust document did not authorize that distribution. Um, these are really big no-nos when you're a trustee. Again, personal liability kind of attaches to this role. So if you make mistakes, the trustee is exposed to some real risks. And um, the trustee, I think I'm reiterating this, but the trustee, when making distributions from a special needs trust, we're trying not to violate very specific government rules that determine whether the beneficiary maintains eligibility for the benefit. Um, so not only does the trustee need to have kind of a firm understanding of the role of the trustee, but they also need to be able to identify situations when it's a really good idea to seek help from an attorney. So like I said, there's benefits attorneys out there who focus on these benefits rules, and they can help your trustee navigate these situations. Um, I have clients. In my practice, I have a lot of my clients name family members, and that's okay. It's just I make clear to my client that hey, you need to have a conversation with your family member and tell them, hey, whenever I die, you need to go out and get an attorney. Give Rebecca a call, whoever it is, get an attorney so they can help you do a good job serving as trustee. And also, I have trust protector. The trust protector can be helpful. So under Arizona law, you can name an individual, designate them in your trust to serve as a trust protector. I'm going to touch on this a little bit later, but the idea is you're just trying to provide some resources, a built-in resource with the trust protector for your trustee. So if they ever need help, they know who to call. Okay, so when you name a professional or a corporate trustee, what does that look like? Well, with professional trustees, this is their day job. They serve as trustee all the time. They know what their job is. They understand the role. So some benefits to naming a professional trustee is that they're going to ensure that there's compliance with state and federal laws to maintain the beneficiary's eligibility. They're better situated to perform the financial responsibilities. They're knowledgeable in the trust administration process, so they're not going to make simple mistakes just by not knowing exactly the terrain they're dealing with. With corporate trustees, like naming a bank or other financial institution, these entities are unlikely to dissolve. So there's less of a need for developing that succession of individuals. You could just name Chase Bank or some other corporate trustee because Chase Bank's always going to be there. Um, in Arizona, there are many private fiduciary companies who will serve as trustee. And with naming a private fiduciary when compared to some other bank or financial institution, their fees will be more conservative. Um, and in my experience, the private fiduciaries always have fee schedules so you can review and get an understanding of what the trustee is going to charge and how they're going to be paid before you name them as a successor trustee. Some cons of naming a professional as your trustee. Number one, it costs more than naming a family member. So most do require some type of a fee to act as your trustee. Um, Another downside can be that a professional, they actually do understand that personal liability goes along with their position. If they make a mistake, they're going to get sued. So they're going to be way more cautious and conservative when they make distributions. So depending on what the situation is, it's something to think about. So some other tools that can be utilized whenever you're doing some special needs planning is designating a trust protector in your special needs trust. So you can name the trust protector, designate a person to serve as trust protector who can be kind of an advisor to the trustee. The trust protector will know more about the intentions and the desires of the trust makers, the parents. Um, and typically, in the trusts that I draft, 9 times out of 10, I'm naming myself as the trust protector, as the drafting attorney, because I will have known the trust makers. I know the parents. I have notes in my file about why they did what they did. I have some knowledge about trust law and tax law. Um, you can also name like a family CPA, or other individual with some trust law knowledge, tax law now knowledge. And the point is with the trust protector is that you can give the trust protector powers and authorities that the trustee can't have. So, for example, I usually give the trust protector the power in the trust document to replace a trustee who is not responsive to a beneficiary's needs. So, if the trustee kind of goes AWOL or is not acting appropriately, I want to make sure that we can, investigate the situation, find out what's going on, and remove that trustee if it's needed. Another power that I usually always give to a trust protector is the power to mediate a dispute between the trustee and a beneficiary, or the trustee and a legal guardian. I had one situation arise where the trustee was the beneficiary's brother, and the trustee was a bit of a pushover, and other family members would regularly try to manipulate the trustee into making distributions for this beneficiary who happened to have a gambling problem. And so, you try to find the right individuals to serve as trustee. The trustee, it's good to have them have the ability to say no, but sometimes, depending on the situation, you want a hard backstop in the trust protector to say, no, I can't make the distribution because the trust protector said I can't. And that's just fine. Um, Another tool that can be useful with special needs planning is what's called a letter of instructions to the trustee. So, with your trust document, under Arizona law, it's a document that it's private in Arizona. It can be totally private. You don't have to file it with the court. You don't have to record it with the county. Nothing like that's required. However, with a special needs trust, the trust document will, in all likelihood, be reviewed by others, whether it's a government agency or a financial institution. Um, so sometimes it's not always the best course to put sensitive, detailed information in the trust document itself. And with a letter of instructions, the trust makers can provide necessary information to a trustee who's might be a non-family member. Maybe they've named a private fiduciary to serve as the trustee. So, for example, specific information regarding the beneficiary's needs or sensitivities or likes or dislikes or medical details about what their condition is. Um, and the trust makers can also set forth some guidelines for the trustee so that they can give the trustee an idea of how they want them to manage. Um, Another tool is an, an advisory panel. to the trustee. I haven't used this one too much in my practice, but basically, you're selecting other family members to advise the trustee. This again can be helpful if the trustee is not familiar with the beneficiary, if you've named a private fiduciary or a bank. Um, and this can be really helpful to identify other needs of the beneficiary, especially when the beneficiary can maintain a level of independence. So if the parents want the child to maintain an independent lifestyle as much as is appropriate, maybe an advisory panel is a good way to handle that if you've got a trustee who's not familiar with the beneficiary. So again, this isn't for every case, but it can be helpful to maintain family involvement with the trust and the trustee and also provide some oversight. Uh, with funding the trust, this is another big issue potentially is what assets will go into the trust. So whenever the parents die, what will the trust assets look like? A lot of times it's real property, the house that you live in. Will the property be sold by the trustee? Will the beneficiary continue to reside in the property? Um, if the parent's estate is heavy with retirement accounts, such as IRAs, 401ks, Roth IRAs, with these aren't always the best assets for a special needs trust because you'll have very negative tax consequences whenever you take the money out of the IRA. And that's just because whenever you contribute money to your IRA, you're taking an income tax deduction. You're not paying taxes at that time. So there's really specific IRS rules um, that govern how that money is taxed when you take it out. Um, if you have life insurance proceeds, usually this is the best kind of asset that you can put in a special needs trust. I'm a big proponent of term life insurance. Whole life insurance can be appropriate in some cases. Life insurance can be really good. Also, second to die life insurance policies for married couples. Essentially, you have one life insurance policy that insures both spouses so that upon the death of the second spouse, the death benefit goes into the trust. So life insurance is always really a good asset for special needs trust because the proceeds are totally liquid. It's cash for the trustee to spend right away if that's needed. And he could invest, the trustee could invest the money if no expenditures are needed right away. They have the flexibility to do either. And also, there's no extra legwork for your trustee when it comes to life insurance proceeds. So, for example, the trustee doesn't have to bother with figuring out how to sell the house if the market's down. They don't have to wait out trying to get fair market value and all those issues. Um, the trustee doesn't have to make withdrawals from the IRA and worry about those negative tax consequences. So, life insurance is always a really good asset to have and maybe explore if you don't have it at this time. I think that is the conclusion of my presentation. So I can take questions if there are any.
All right. Thank you so much, Rebecca. So now we do have someone else in here. If you have any questions, you can go ahead and type it in the chat box. Rebecca, I have a quick question. Well, I have a couple questions,
Yeah.
but I want to hit one that you just talked about. So you said that IRAs, 401ks, and Roths are not really good things to put in your special needs trust. So what do you do with them?
So usually, if you have an estate, so your estate is all that you have, all that you own, all of your assets. If the estate is heavy with IRA money, a lot of assets in 401ks or IRAs. Um, I do some counseling with the client on maybe how to leverage those IRA assets to purchase a life insurance policy
Okay.
because you can basically and you can talk to, a life insurance advisor. I don't sell life insurance. You can talk to someone who can, show you the premiums, the death benefits, and what you'd be paying every month or every year in premium so that it makes sense to you.
Okay.
Um, but basically, what you're trying to do is take some of the retirement money and use your RMD, your required minimum distribution that you take out whenever you're 59, um, and use that money to maybe purchase a life insurance policy so that we shift some of this money into another bucket of money
Okay.
where, okay, we know we're going to have $500,000 or $200,000 that's
Okay.
going to be taxed in a way that is the best.
Okay. So it's almost better to use that money, like you're saying, in other ways. I mean, maybe even buying more properties to have.
Yeah. So depending on, because I have a lot of folks who are a little squeamish about life insurance. I get it. So it's just kind of making sure that you understand the issue and how those accounts will be taxed so that you can make a good decision for yourself.
Yeah, that's something I didn't really think about. So something I'll have to start talking to my husband about. The other thing I was wondering, so Matt and I set up our estate planning document before our kids were diagnosed. And so now that they're diagnosed, we know we have to have a special needs component in there, but do we have to reinvent the whole wheel, or can you insert your special needs trust into what you already have built?
So that's a really good question. You don't have to reinvent the wheel, so to speak. A lot of times you can just do kind of a short amendment to your trust.
Okay.
And depending on what your trust says already, a lot of times the trustee of the trust in the
Mhm.
trustee powers, the trustee will have the power to create a special needs trust if it's appropriate. So that could already be in there as well. I think um, you should definitely talk to your attorney and see what's best for your situation, but you don't have to reinvent the wheel if you already have an established estate plan.
Okay. Um, the other thing I thought was really interesting. So you talked about the difference between revocable and irrevocable trusts, and you kind of had a caveat at the bottom. It depends on if you want people to be able to make money donations to those trusts. So why is it different with the revocable or irrevocable trust, and how people can donate to those trusts? Is that like a tax thing?
So it's not necessarily a tax thing.
Okay.
With an irrevocable trust, you're creating a trust that can't be terminated. So it's not going to go away.
Okay.
You can't totally revoke the trust, make a change to the trust to terminate it. So it kind of provides some reassurance to your family members. So, for example, if you have grandparents who want to provide for your kids, um, you can give them, okay, this is the trust name and the trust EIN, and then they can go update their beneficiary designation for their life insurance policy and put the trust name there.
Okay.
They will know, okay, this trust, I have the information here. It's not going to go away. It's irrevocable. It's just there.
Okay.
Whereas with a revocable trust,
Okay.
yeah, you could give them the name and everything, but they don't, you can't tell them for sure, yeah, in 20 years, this is still going to be up and running. Like your life could change dramatically and that
Yeah.
trust could be dissolved.
Okay. That's
And
nuts. So it's more like a reassurance, comforting thing for people who are
yes,
donating.
and a lot of times it's heavily dependent on what kind of assets that you're dealing with. Like if you have um, like some wealthy parents, wealthy grandparents who want to establish a separate special needs trust that's irrevocable and name your child as the beneficiary of that irrevocable special needs trust, they could do that themselves. So it's totally based on facts and circumstances of who the client is, and what's going on, and what the objectives are. I'd say 9 times out of 10 in my practice, I'm setting up a revocable trust with provisions that provide for the special needs trust to be created for a disabled beneficiary upon the death of the parents.
Okay.
And that's pretty typical.
Okay. That's cool. Um, this other thing. Oh, I really liked this was the first talk I've ever heard somebody talk about the trust protector. And I was like, that because that's the thing I think that terrifies me more than anything is that yes, I have this person that I trust who I, think would be a good trustee, but then, what if life happens? Like who do they go to as like that backstop? And I thought that was such a great insight.
Yes. So, with your trust protector provision, again, it's unique to Arizona law, and you can even name a succession of trust protectors. So, like if I'm naming myself as the drafting attorney, who takes over if I die or if I stop practicing? You want to make sure that there's flexibility in all of these major role players, and so it can be beneficial for a
Okay.
trustee to have a trust protector.
Okay. I think I had just one more question. When you talked about the letter of instructions, so you said that those are more like private notes, but are those things that you put in there, are those like legally binding, or is it more like these are just my wishes that I hope that you carry out?
So the letter of instructions to the trustee is just kind of an ancillary document. It's kind of informal in nature, and it's not legally binding per se on the trustee. So it's meant to be kind of a guideline for the trustee. But in many cases, it can be useful because the trustee is going to need some information on maybe a medical condition and how the beneficiary responds to certain living arrangements, like any type of
Yeah.
sensitive information that you only know as the parent or maybe other family members might be familiar with. That can be really helpful to the trustee.
Okay. I'm guessing that letter is probably the most thing that's updated consistently because
Yes, and with
that's,
something like that,
yeah.
you're free to make changes to that document as you see fit going forward. You don't even have to go through your
Okay.
attorney every time. It's just something that you can keep with your trust documents. You can keep it in your estate planning notebook with your other documents, and it's for the trustee um, for informational purposes.
Okay. All right. I think that those were all of the questions that I had. This was real. I got like 3 pages of notes. So it was really, really informative. And I appreciate you being here and contributing and taking some time to, answer the questions. And I see that you put your website up there. Is there contact information on the website for you in case people have other questions?
Yes, I was going to mention if any questions arise after some of your members view this presentation, feel free to have them give me a call. My phone number should be on the website. I can do an informal call just to kind of field some general questions. I'd be happy to do that. Or we can schedule a consultation at my office and we can do kind of a more detailed review of the situation. So I'm happy to make myself available.
Awesome. Well, thank you so much, Rebecca. I really appreciate you being here today.
Thank you.
All right. We'll see you later.